Okay, now I'd like us to cross over to the Milimani Law Court, where Sarah Wairimu is appearing before the High Court on the charge of murder, and that has to do with the murder of Dutch tycoon Tob Cohen. And let's listen in.
Of interest. Mr. Murgor, on the other hand, contends that he resigned as a public prosecutor effective 7th of March this year, and that he is no longer a public prosecutor as argued. He argues that he is properly before this court as defense counsel for the accused in this matter. This dispute leads to the issue before me, whether Mr. Murgor, while still a public prosecutor as contended by Mr. Mbeta and Ms. Mwaniki, can still purport to act as defense counsel for the accused. The Learned Counsel buttressed their contentions on the lack of evidence of revocation of that appointment of Mr. Murgor as a public prosecutor. It is also clear to me that there is no dispute that Mr. Murgor tendered a letter of resignation as a public prosecutor. The letter of resignation was accepted and receipt of the same acknowledged. This is not denied by the prosecutor, Ms. Mwaniki or Mr. Mbeta. The only condition on the issue being that the letter of resignation cannot override a gazette notice revoking an appointment or this appointment in issue. In the words of Mr. Mbeta, the letter of resignation is not conclusive proof that Mr. Murgor is no longer a public prosecutor. I note further that it is not denied that Mr. Murgor continues to attend courts in criminal matters as a defense counsel. There are no submissions from Ms. Mwaniki or Mr. Mbeta countering the submissions by Mr. Murgor that he has been attending court as defense counsel in other criminal matters and also in this particular case. It is noteworthy that there is no evidence presented to this court showing any objection raised against Mr. Murgor's standing as defense counsel in this matter, in this court or in other courts from the time he first appeared as defense counsel up to 26th of September this year when this objection was raised. It was not denied that Mr. Murgor is in his capacity as defense counsel in various criminal matters as directed with his own DPP in general and Ms. Mwaniki in particular. The fact that Mr. Murgor has been representing clients charged with criminal matters as defense counsel is known to the ODPP. This was after the letter of resignation. It is also clear to me that there is no dispute that Mr. Murgor, upon resigning as a public prosecutor, returned all the documents relating to the particular case he was assigned, and that was acknowledged. The letter dated 14th of March 20 this year marked PKM 10. This fact has not been denied either by Ms. Mwaniki or Mr. Mbeta. Mr. Murgor claimed that the objection raised in this case was calculated to delay the plea taking in this matter, and as such it contravenes accused right to fair trial as provided under Article 50 of the Constitution of Kenya. He also claimed that by arguing that he is still a public prosecutor and denying him the chance to represent clients against the DPP is in violation of his rights and Article 30 of the Constitution. I've looked at those articles. The Article 30 is about, or rather reads as follows. Number 1, a person shall not be held in slavery or servitude. And number 2, a person shall not be required to perform forced labor. And I think the argument by Mr. Murgor is that he is being forced to do exactly that. Article 50 of the Constitution of Kenya guarantees an accused person the right to a fair trial. This right includes the right to be presumed innocent until the contrary is proved, a right to be informed of the charge with sufficient detail to answer to it, a right to have the trial begin and conclude without unreasonable delay, and also a right to choose and be represented by an advocate and to be informed of this right promptly. I need to point out that the rights under Article 30 and 50 of the Constitution of Kenya cannot be limited. This is by dint of Article 25 of the Constitution of Kenya. I have read and understood the authorities cited by Mr. Murgor. This is the Okia Omtata case, and in this and another one that is Eric Cheruyot and others. The Okia Omtata case concerns 3 commissioners of the Independent Electoral and Boundaries Commission who on the 16th of April 2018 addressed a press conference publicly announcing their resignation from the IEBC with immediate effect. The 3 commissioners also sent giving rise to that particular petition, and they held the view that although they had publicly announced their resignation and notified the president as required by the law, there was 2 commissioners because it was up to the president to actualize their resignation by publicizing vacancies in the offices of 3 commissioners in a Gazette notice. In determining that matter, the court, that is Mr. J, observed as follows, and I quote, "It is plain from the reading of the constitutional text that there is no provision for a commissioner's resignation. The Constitution speaks of removal from office, which means that the action to remove a commissioner is third-party driven as opposed to self-desire to leave. That cannot, however, mean that a commissioner who desires to leave cannot resign because the Constitution does not allow it. In my respectable view, a commissioner, just like any other person, has a constitutional right to leave the commission if he wishes, and no one can stop him. To leave employment is a right to make a choice, and therefore a constitutional right that cannot be limited, as it is not legally possible to force one to keep a job he or she does not wish to." And the court continued, and as the Supreme Court observed in John Arun Mwang and 2 others versus IEBC and 2 others, that no one could be forced to participate in an election he has lost interest in. In the same vein, there is no way a commissioner can be forced to remain in office if there is no longer such motivation, simply because there is no constitutional provision for resigning from office. The court in the same matter, Okiya Mutata, continued to state as follows, and I quote again, "Furthermore, from the reading of the statute, the president does not have discretion whether or not to accept the resignation. He is only notified by the commissioner of this resignation, and the president's mandate is to initiate the rest of the process by declaring a vacancy, which leads to the process of recruitment. In that respect, therefore, it is my finding, and I so hold, that the resignation of a commissioner is immediate upon notifying the president in writing of that resignation, and publication of the vacancy in the Gazette is a formal step and has no bearing on the actual act of resigning." I end the quote. In the same vein, the court in the Eric Cheruyot case, also cited by Mr. Murgor, was of the view that resignation is a unilateral act that does not require acceptance. I've given this matter, the issue before me, much thought and consideration. I find that I'm persuaded by the authorities cited, and also the provision of the Constitution on the rights are cited above. Although in the Okiya Mutata case, the issue before the court was based on a statute providing for the manner in which removal from office should be undertaken, I find the same principle in that case relevant and applicable in this case. The reasoning of the courts in both cases is of persuasive value to this court. My view is that no person should be forced to remain in office once they have chosen to resign from that office. I agree with Mr. Murgor that his resignation, as contained in the letter dated 7th of March 2019, was immediate upon submitting to the appointing authority the letter of resignation of that date, which letter was received and that receipt acknowledged. It is my finding, and I so hold, that the appointing authority did not have discretion in the matter. Publication of a Gazette notice revoking that appointment, that is appointment of Mr. Murgor as public prosecutor, in my considered view is a formal step by the appointing authority, and that step has no bearing on the actual act of resignation of Mr. Murgor as submitted by Mr. Murgor, which submissions I agree with. The publication in the Kenya Gazette is meant to notify the public, but not to change the fact that he has resigned as a public prosecutor. Consequently, the objection raised by Mr. Mbeta and supported by Ms. Mwaniki is hereby rejected. I find that Mr. Murgor is properly before this court as a defense counsel for the accused person. I find that his representation of the accused person in this case does not raise a conflict conflict of interest on his part, since his resignation as public prosecutor is effective from the time the letter of resignation dated 7th of March 2019 was received and acknowledged by the ODPP. I make orders accordingly.
Most obliged, Your Excellency.
Yes. Yes.
High Court Judge Stella Mutuku delivering her ruling on Philip Murgor's suitability to represent Sarah Wairimu. The Office of the Director of Public Prosecutions and the family lawyer Cliff Ombeta had argued that he is a public prosecutor and therefore is not rightly before the court as her legal counsel. But as you heard the judge say, it's a formality. The gazettement is more of a formality on the part of the office of the DPP, and that he resigned, and that is sufficient.